The Chairman of the Economic and Financial Crimes Commission (EFCC), Abdulrasheed Bawa, had been sentenced by a high court sitting in Federal Capital Territory (FCT) in Maitama for contempt. Bawa was convicted by the court in connection to the Commission's failure to comply with an earlier order of the court. Justice Chizoba Orji ruled that Bawa should be committed to Kuje prison for his infraction of court order. Justice stated that the Chairman of EFCC is in disdain of the order of his honourable court made on November 21, 2018, directing the Economic and Financial Crimes Commission, Abuja, to return to an applicant his Range Rover, Supercharge, and the sum of 40 million naira. Having continued willfully in disobedience to the order of this court, he should be sentenced to prison at Kuje Correctional Centre for his disregard and continued disobedience of the said order of the court made on November 21, 2018. Until he purges himself of this contempt, the Inspector General of Police shall ensure that the order of this honourable court is executed immediately. The presiding judge rejected the arguments put forward by the lawyer to the EFCC, Jirbo, to justify the action of the EFCC Chairman. The ruling was delivered with respect to a motion unnoticed, marked FCT HCM 52 2021, filed by Air Vice Marshal AVM Rufus Adeniyi Ojuawo, a one-time Director of Operations at the Nigerian Air Force. Ojuawo had, in a motion filed by his lawyer RN Ojabo, in a suit marked FCT HC CR 184 2016, complained that the EFCC refused to comply with the order for the release of his seized property made by the court in a judgment delivered on November 21, 2018. The EFCC had indicted Ojuawo on a 2-count charge before Justice Muawiya Baba Idris of the High Court of the FCT in Inyanya in 2016. But in a judgment on November 21, 2018, Justice Idris discharged and acquitted Ojuawo on the grounds that the prosecution failed to prove its case. Idris held that for the charge to succeed, the prosecution must prove that the defendant corruptly accepted the gift, that he accepted or obtained the gift for himself or for any other person. The judge added that the prosecution also ought to prove that the defendant accepted the gift in the course of or for discharging his official duty, and that the gift was stimulation or reward. He held that the burden was on the prosecution to prove all ingredients of the charge preferred against the defendant beyond reasonable doubt, as required under Section 131 of the Evidence Act 2011. Justice Idris had said in conclusion, "I hold that the prosecution has failed to prove the 2-count charge of corrupt gratification under Section 17, 1A and C of the Corrupt Practices and Other Related Offences Act 2000. The defendant is discharged and acquitted on counts 1 and 2 of the charge. Hence, the complainant, EFCC, is ordered to refund the defendant his 40 million naira wrongly paid into ONSA recovery account and to return to the defendant his Range Rover Sport Supercharge straight away."